A federal judge just tore apart Pam Bondi's Department of Justice, and what's buried inside that ruling could unravel hundreds of federal cases that directly affect ordinary Americans. 130 pages. A withering, meticulous legal demolition. And by the time it was over, federal prosecutors in at least one major district had been stripped of their authority, and the entire structure of how Bondi built her DOJ was put on trial. This isn't a political fight dressed in legal language. The documents are specific. The law is clear. And the consequences are already spreading to active prosecutions across the country. Here's what the ruling actually says and why it matters far beyond Washington. When Pam Bondi took over as Attorney General in January of 2025, she inherited a department already under serious strain. Career attorneys were walking out. Long-serving prosecutors had quit or been pushed. The Civil Rights Division was hollowed out. The National Security Unit was bleeding talent. The environment was chaotic from day one. And rather than work within the constitutional structure for filling those vacancies, Bondi moved fast and moved outside the rules. The Federal Vacancy Reform Act exists for exactly this situation. It is a law Congress passed specifically to prevent executive branch officials from installing unconfirmed loyalists into positions that are supposed to go through Senate confirmation. The law sets strict limits who can serve in an acting capacity for how long and under what authority. It is not optional. It is not subject to personal interpretation by the Attorney General. It is federal law, written, passed, and enacted to protect the constitutional separation of powers. The core principle behind the law is simple. When a Senate-confirmed position becomes vacant, you can fill it temporarily, but only under specific conditions. The person you install must meet certain qualifications. They can only serve for a defined period, and they cannot exceed the authority of the office they are temporarily filling. Congress drew those lines deliberately. Because the founders understood that the power to appoint is the power to control, and a president who can fill the entire federal law enforcement apparatus with hand-picked loyalists, bypassing the Senate entirely, is a president who has effectively dismantled one of the Constitution's most important checks on executive power. Bondi's team violated that law, not once. Not in a gray area technicality, across multiple districts, multiple divisions, multiple officials installed without legal authority to serve. Judge Matthew Bran, sitting in the Middle District of Pennsylvania, issued his ruling in March of 2026. He was blunt in a way federal judges almost never are. He described the DOJ's defense of the arrangement as a rhetorical smokescreen. He wrote that 1 year into this administration, it had become plain that the Trump team chafed at the limits on their power set forth by law and the Constitution. He warned that scores of criminal prosecutions could collapse as a result. The judge stayed his ruling pending appeal, but issued a stark warning with that stay. Any further illegal appointments, he wrote, will result in criminal charges being dismissed. Not threatened, not delayed, dismissed. That is a judicial ultimatum backed by 130 pages of documented findings. The specific situation that triggered the ruling, after Alina Habba, Trump's former personal attorney, was quietly pushed out of her role as interim U.S. Attorney for New Jersey last December, Bondi tried something the legal system had never encountered before. Rather than go through proper appointment channels, she split the U.S. Attorney's Office into 3 separate operational fragments. She designated 3 officials, Jordan Fox, Philip Lamparello, and Ari Fontecchio, to run the criminal, civil, and administrative functions of what is legally supposed to be a single presidentially appointed Senate-confirmed office. Fox had been with the DOJ for less than a year. Judge Bran dismantled the arrangement piece by piece. He called it an enormous assertion of presidential power. He said Bondi had unilaterally fractured the power of an office that Congress designed to be unified and accountable. The ruling was comprehensive, specific, and critically not close. Now, here's where this stops being a Washington story and starts becoming your story. New Jersey is not isolated. Courts have now disqualified Trump-installed prosecutors in at least 5 separate states. 5 courts, 5 independent rulings. The same core legal problem identified by judges across different circuits appointed by presidents of both parties, all reaching the same conclusion. Officials installed without lawful authority cannot exercise the powers of offices they were improperly placed in. Judge Bran looked at that 5-state pattern and wrote something that should be read carefully. He said it reflects an administration that cares far more about who is running these offices than whether it is running at all. That was not editorializing. That was a factual conclusion drawn from the evidence in the record before him. Let's be precise about what that 5-state pattern means in concrete terms. In each of those jurisdictions, every prosecution initiated by an unlawfully appointed official is now legally vulnerable. Every charging decision, every grand jury convened, every settlement negotiated and signed by someone the court has now found had no signing authority. That is not a theoretical concern. That is an active legal crisis playing out in real time across the federal system. Each of those 5 disqualifications carries its own set of downstream consequences. Criminal defendants are filing motions. Corporate defendants who signed consent decrees are having every page reviewed by their legal teams. Civil enforcement targets are questioning whether the officials who built cases against them had any lawful authority to do so. And defense attorneys everywhere are now asking a question they have never had to ask systematically before. Was every official who touched my client's case properly appointed? That question is now a professional obligation, not just a creative defense theory. Courts have accepted it. Judges have ruled on it. It is real. The grand jury problem is among the most serious. A separate federal judge already quashed grand jury subpoenas issued out of a district where the acting U.S. attorney was found to be unlawfully appointed. Those subpoenas were not delayed or rescheduled. They were thrown out entirely. The active investigation they supported collapsed. That is the remedy when the government skips the rules, not a procedural correction. Dismissal of the work product. Now let's talk about the prosecution that has received the most political attention in this context, the case against former FBI Director James Comey. When the Bondi DOJ moved to prosecute Comey, the case was supervised by an acting U.S. attorney named Lindsay Halligan. Her appointment drew immediate legal challenges. Courts questioned whether she had authority to supervise grand jury proceedings at all. Bondi's response was a retroactive ratification, a document signed after the fact to try to cure what she was implicitly acknowledging was a potential flaw in Halligan's legal standing. The Fourth Circuit Court of Appeals is still deciding whether that retroactive fix is legally valid. In the meantime, the Comey prosecution has not proceeded to indictment. The DOJ struck out in its renewed efforts. And the Letitia James investigation, another politically visible target, saw its grand jury subpoenas quashed by a federal judge who found the acting U.S. attorney who issued them was not lawfully in office. This is the cost of bypassing the constitutional rules. Not bad press, not embarrassment. Actual prosecutorial collapse on the very cases the administration wanted most. Now let's give the other side fair credit, because they have a genuine argument. DOJ defenders say this is judicial overreach, unelected judges micromanaging executive branch staffing during a real institutional crisis. And the crisis is real. By the time the Bran ruling dropped, an estimated 500 attorneys and staff members had quit the DOJ, been fired, or taken buyouts. That number is from the American Bar Association's report of November of last year. 2/3 of the attorneys specifically assigned to defend the administration's own signature policies had walked out. The department was severely depleted. Bondi was trying to fill empty seats in a hostile environment with anyone willing to serve. Deputy Attorney General Todd Blanche argued publicly that courts have no authority over how the Attorney General staffs her department, that these are internal executive decisions beyond judicial review. He stated that position twice on social media. Judge Bran addressed it directly in his ruling, cited the statute, and explained precisely why Blanche was wrong. The Federal Vacancies Reform Act explicitly grants courts supervisory authority under these exact circumstances. The DOJ also argues that even if the appointments were technically defective, the outcome shouldn't automatically collapse. That harmless error doctrine should protect the results. Judge Bran rejected automatic voidance, but found the actions voidable. That is the worst legal outcome for the government. It doesn't wipe everything out instantly, but it opens the door for every affected party to challenge every affected decision in every affected case. That door is now wide open. So what does the administration do from here? There are three realistic paths. First, replace every challenged official with a properly appointed replacement through lawful channels. That is the clean solution and the slowest one. Second, win on appeal. The Third and Fourth Circuits will determine whether these rulings stand. The legal record is detailed and well documented, which makes reversal difficult but not impossible. Third, take it to the Supreme Court. The court has never directly ruled on many of the Federal Vacancies Reform Act questions at the center of this litigation. That unresolved territory is the administration's strongest remaining legal argument that these are genuinely open constitutional questions requiring the highest court's guidance. But all of it takes time. And while the appeals unfold, the affected cases remain in legal limbo. The 21-day disclosure deadline in related proceedings is running right now. When that accounting arrives, the full list of every decision made by every official now under legal challenge, the scope of this crisis will be publicly visible for the first time in full. Bondi's public response to all of this has been revealing in one very specific way. She has called the rulings radical judicial activism. She has accused judges of trying to reverse an election through the courts. What she has not done at any press conference, in any filing, in any public forum, is explain why her appointments were legal. She has not cited the statute. She has not walked through the analysis. She has not engaged with the factual record. When the facts are on your side, you argue the facts. When they are not, you argue the politics. The absence of a legal defense is itself a signal. Whether you support Bondi politically, whether you agree with the administration's agenda, whether you believe these prosecutions should succeed, the mechanism matters. The law matters. Because the same constitutional rules that constrain this administration today are the rules that protect you from any administration tomorrow. That is not a partisan argument. That is constitutionalism. Watch the Third Circuit. Watch the Fourth Circuit. Watch the disclosure deadline. Watch the motions being filed in federal courtrooms across the country this week. This story is accelerating, not slowing down. Subscribe and you will have the full breakdown the moment the next ruling drops. But let's go deeper on the personal impact question, because this is the part that most coverage misses entirely. Think about who interacts with the federal government on a regular basis. Not just defendants in criminal cases. Not just corporations under investigation. Think about anyone who has been subject to a federal civil enforcement action. Think about the businesses, nonprofits, healthcare providers, financial institutions, and employers who have reached settlements with the Department of Justice in the last 2 years. Think about the individuals who had federal charges filed against them, had grand jury subpoenas issued in proceedings related to their conduct, or were part of ongoing federal investigations that have not yet resulted in charges. Every single one of those situations may now involve a decision made by an official the courts are calling unlawfully appointed. For corporations, the exposure is concrete and immediate. A company that paid tens of millions of dollars to settle a federal enforcement action does not want that settlement reopened. But their legal teams have a fiduciary obligation to explore every viable challenge. And a viable challenge now exists. Some companies will conclude the risk is not worth the cost of litigation. Others will not. The ones who decide to fight will use exactly the legal argument that Judge Bran's ruling now supports. For individuals in the criminal system, the stakes are even higher. This is not about money. This is about liberty. If a person was charged by a grand jury that was convened under the supervision of an official who lacked lawful authority to supervise it, that is a constitutional due process argument. Courts take due process seriously. Not every judge will accept that argument, but some already have. And every defendant whose case fits that profile now has a right to raise it. For witnesses who testified before grand juries run by these officials, there are questions about whether their testimony was gathered through a lawfully constituted process. For targets of investigations that have not yet resulted in charges, there are questions about whether evidence collected during the investigation was gathered under lawful authority. None of this is abstract legal theory. All of it is being litigated right now today in real federal courtrooms across 5 states and potentially more. Now step back from the individual cases and think about what this moment means for the institution itself. The Department of Justice is not just a law enforcement agency. It is the institutional embodiment of the principle that in the United States, the government is bound by the same law it enforces. When the DOJ prosecutes someone, it is acting in the name of the people, all of the people, under a legal framework that is supposed to apply equally to the powerful and the powerless. That framework includes the Federal Vacancies Reform Act. It includes the Appointments Clause of the Constitution. It includes the confirmation process that Congress and the founders designed as a check on executive power. When the DOJ bypasses that framework to install officials who were never vetted by the Senate, who never went through the accountability process that the Constitution requires, the institution's fundamental claim to legitimacy is weakened. Not destroyed, weakened. But weakened in a way that has real consequences for the cases it brings, for the defendants it prosecutes, for the public that relies on it to act lawfully. The mass departure of career attorneys was not just a staffing problem. It was a signal. 5,500 people who had dedicated careers in federal law enforcement looked at what the Bondi DOJ was becoming and concluded they could not continue. The American Bar Association's November report cataloged that departure with specificity. The DOJ is now recruiting prosecutors with zero prior experience, people who have never worked a federal case, to fill seats that used to be held by attorneys with decades of institutional knowledge. That is not a temporary adjustment. That is a structural degradation that will affect the quality of federal law enforcement for years. And it is the direct consequence of a leadership strategy that prioritized loyalty over legal compliance. The courts are drawing the line. Multiple courts, multiple rulings, multiple circuits. The Third Circuit will decide whether the Bran ruling stands. The Fourth Circuit will decide whether Bondi's retroactive ratification of Halligan's actions was legally sufficient. The Supreme Court may ultimately weigh in on the Federal Vacancies Reform Act questions that have never been definitively resolved at the highest level. But while those appeals unfold, the consequences are accumulating. Motions are being filed. Cases are being challenged. Settlements are being reviewed. And the institutional damage to the DOJ's credibility, to its workforce, to its ability to prosecute cases that will survive appellate scrutiny is compounding every day. Here's what the next 30 days look like. The Third Circuit appeal is the most immediate inflection point. If the court affirms the Bran ruling, the legal pressure on the DOJ becomes overwhelming. Officials must be replaced, affected cases must be disclosed, and the administration faces a cascading set of legal obligations that it will struggle to meet. If the court reverses or stays the ruling, Bondi survives the immediate crisis, but the legal fight continues through the appellate system, possibly for years. The 21-day disclosure deadline will produce a public document that for the first time shows the full scale, every prosecution, every settlement, every enforcement action touched by officials whose appointments are now in question. That document will be filed in a federal court. It will be public. Journalists, defense attorneys, corporate lawyers, and political opponents will all have access to it simultaneously. Whatever is in it will drive the next phase of this story. The Senate Judiciary Committee has announced hearings. The named officials, some of whom are reportedly considering resignation, will face questions under oath. Their answers will shape the legal record in the ongoing appeals. This is not reaching a conclusion. This is reaching a critical mass. And the only question now is whether the constitutional framework holds or bends. Stay locked in. This story is far from over.